Welcome to Subcommittee's sixth discussion today on the regulatory state. We are examining today federal agencies' use of guidance in the regulatory process. Guidance is one of the most common ways that agencies communicate with the American public and one that receives little oversight. In order to better understand how guidance fits into our regulatory scheme, it might first help to take a step back and look at the full picture. And that always begins with us, with Congress, writing and passing laws that provide statutory authority to agencies to implement our intent. It's one of the areas that the ranking member and I have talked about often, that Congress has a responsibility to be able to write clear statutes. Agencies have only as much rulemaking power as we grant them, so it's incumbent on us to use our legislative power judiciously while simultaneously exercising oversight of how those agencies use their regulatory authority. Agencies armed with rulemaking authorities promulgate regulations. Regulations are legally binding statements of policy that are legally enforceable, and those who fail to comply face consequences such as a hefty fine or even jail. When Congress granted agencies this expansive rulemaking power, it also placed some requirements on the promulgation of regulations. Many of these requirements can be found in the Administrative Procedures Act. Administrative Procedures Act requires agencies to publish a notice of proposed rulemaking in the Federal Register and receive public comment before they promulgate rules. Notice and comment is critical for the agency to gain feedback from potentially regulated parties, and is likewise critical to the American people to ensure that rulemaking is transparent and fair. In order for the federal government to work for the people must have a voice in the rulemaking. Congress, cognizant of the complexity of administrative law and the need to get certain timely information out to the affected parties, also provided in the APA an exception to rulemaking requirements for interpretive rules and general statements of policy. These terms are often grouped together under the umbrella of guidance. Guidance is a helpful tool when, for example, agencies merely wish to clarify or define a point of ambiguity in existing regulation. The APA acknowledges that agency guidance is useful by exempting it from its notice and comment requirements. Therefore, when an agency chooses to issue a guidance document in lieu of rulemaking, it may, for example, publish it on its website and do that immediately. But the benefit of guidance that it bypasses notice and comment and therefore can be readily issued comes with a catch. Guidance may not impose legal obligations on the agency or on the parties it regulates beyond those inherent in the rule that it clarifies. Given these characteristics, that guidance is not legally binding, but merely re-articulates a regulation's existing legal requirements and regulated parties' obligations under those requirements, it can be very difficult, even for experts, to determine or discern when a document can be rightly called a guidance and when it should go through the rigor of APA notice and comment rulemaking. In fact, the Government Accountability Office, in its most recent report, found the legal scholars and federal courts grapple with these very determinations. I do believe that agencies may issue guidance documents with the best of intentions to clear up confusion or to provide timely information. However, I also understand the concerns and frustration of regulated entities that must sift through huge stacks of guidance with widely varying names to ensure that they are appropriately complying with standards. For example, the Department of Labor has issued guidance documents under various headings, such as advisory opinions, notices to interested persons, brochures, policy directives, bulletins, questions and answers, and circulars, just to name a few. Likewise, the Department of Education issues guidance under the headings such as Dear Colleague letters, memoranda, best practices, frequently asked questions, program memos, and manuals. I hope the discussion we have today will be in service of ensuring that guidance is properly and selectively issued going forward. Today's concern lies with the process by which the decision to issue guidance is made. Circumventing the rulemaking process robs the public of congressionally mandated notice and comment, and it's wrong in and of itself, even if the substance of the policy it articulates is sensible. In the past, for example, independent watchdog organizations and congressional committees have expressed concerns with particular Department of Education guidance. In 2010, 11, and in 14, the Department's Office of Civil Rights issued guidance dubbed as Dear Colleague letters on bullying, sexual assault, and school discipline in higher education. The letters served to significantly expand prohibited conduct in the way in which disciplinary procedures could be conducted and the scope of school liability for failing to prevent prohibited conduct. Especially troubling is the Department of Education is rarely challenged on its guidance, likely because of the department's powerful position. Schools frequently follow improperly issued guidance without question for fear of an investigation that may damage their academic reputation or rescission of federal funding. Because of this, the department may continue to improperly issue guidance in circumvention of notice and comment unchecked by the courts. More recently, the Labor Department's Occupational Health and Safety Administration issued problematic guidance on process safety management and standards. OSHA issued 3 process safety management standards, or PSM, memoranda in June and July of this year. Memoranda subjected many previously unregulated parties to newly burdensome requirements and compounded their compliance costs. To maintain the integrity of the federal rulemaking process, I hope the Department of Labor seriously reconsiders the manner in which it effectively regulated stakeholders within its jurisdiction. Principles of good governance require that the policies in these memoranda are subject to the procedures mandated by the APA. We have a GAO witness present today to discuss these and other findings on use of guidance. I'm grateful for her office's work and look forward to her testimony. Also with us today are officials from the Department of Labor and Education. In May, Senator Alexander, chairman of the Help Committee, and I wrote to the Departments of Labor and Education asking their departments to determine when to issue guidance in lieu of rulemaking. In response, they provided some helpful agency-specific insights, and I look forward to expanding on some of those insights today. I look forward to a detailed discussion on these issues with our witnesses. This is something that is a serious issue. That's not just these 2 agencies. This is a bigger issue. And even in the letter that we promulgated and in other questions that we have, this is not picking on 2 agencies. This happened to be 2 agencies that obviously there are a lot of questions and a lot of guidance documents come out of. As I mentioned before, some of these guidances are good policy. It's the process that we're talking about to make sure that people are actually included into it and ask the question, where do we go from here? With that, I'd like to recognize Ranking Member Heidi Heitkamp for her opening statement.
Thank you, Mr. Chairman.
All of you, and I'm going to do a quick set of questions here, and we'll go through pretty rapid pace on this and just start moving around. Again, I want to reemphasize that a lot of the issues we're going to talk about today are not about the rules themselves, about the process of it, and we'll get a chance to talk through some of that. Just to set some of this up, and then we'll come back in the second round. I'll ask some other additional questions on this to be able to build on it. Ms. Maxwell and Ms. McIntosh, because you're both experts in the guidance process in your agencies, I want to get your perspective on a couple of specific guidance things that have come out that I have a thought that might have gone through notice and comment. We can talk about more later on it and actually go through the rulemaking process. Ms. Maxwell, let me turn to you first. June the 5th of this year, OSHA issued a memorandum with the subject line Reg Gap, which has got to be one of the worst acronyms in government. That stands for Recognized and Generally Accepted Government Engineering Practices. Reg Gap in Process Safety Management Enforcement. Are you familiar with this memorandum? Do you believe that memo is an agency guidance? Was that the perspective that is a guidance document, not a new regulation when that came out? Yes. Okay. If you'll turn your microphone on too, when we go through that, that's fine.
Sorry.
It's all right. June the 5th, OSHA issued a memorandum with the subject line Process Safety Management of Highly Hazardous Chemicals and Covered Concentrations of Listed Appendix A Chemicals. Are you familiar with that memorandum?
Yes.
Do you believe that's also agency guidance?
Yes.
Okay. July 22nd, OSHA issued a memorandum with the subject line Process Safety Management of Highly Hazardous Chemicals and Application of the Retail Exemption. Familiar with that one?
Yes.
Okay, same thing. Do you think that is agency guidance on that?
Yes.
One? Okay. So McIntosh, let me bounce through a few as well, and I think you're prepared for these also. October 25th, 2010, the Department of Education's Office for Civil Rights published a Dear Colleague letter on bullying. Are you familiar with that letter on it?
Yes, I am.
Do you believe that's agency guidance for that?
Yes, I do.
Okay. April the 4th, 2011, Department of Education's Office for Civil Rights published a Dear Colleague letter for sexual assault and harassment. Familiar with that letter as well?
Yes, I am.
Yes. Is that one also agency guidance?
Yes, it is.
Okay. January the 8th, 2014, Department of Education's Office for Civil Rights, DOJ's Civil Rights Division published a Dear Colleague letter on administering school discipline. Are you familiar with that letter?
Yes.
Okay. Also, is that one agency guidance?
Yes.
Okay. Thank you. Ms. Maxwell, on OSHA's guidance, on recognized and generally accepted good engineering practices, this wonderful Reg Gap we talked about before, was Reg Gap intended to be a performance-based standard with flexibility for regulated parties to choose among industry's best practices that were most appropriate for their business? When that was originally set out there, was it performance-based to give flexibility so that they would have that? If so, is that still continuing even under the guidance?
Senator Lankford, I think that the specificity of your question is kind of beyond my personal expertise on that particular issue. But the memo was designed to give guidance to the field on implementing the standard.
Okay. The concern that I have is that the new guidance document seems to remove flexibility that previously existed. And when we try to look at what's guidance and what's regulation and where should we have gone out, it seemed that the regulation gave flexibility to say you have this generally recognized engineering practices, go by those, or you can create your own process. You just have to be able to show that it's a good process. This new guidance seems to remove that or and say, no, everything's got to shift over to this other standard, and the flexibility seems to go away. The reason I draw that out is that seems to be one of those things that would look like that would be a regulation that would need to go through the notice and comment rather than just someone to receive it as well. If it's intended as a flexible enforcement standard, this June 5 seems to take that away. So the question really is a process question. How was that determined this is going to be a guidance rather than a rule that would go out?
So to begin, we follow the APA and the OMB bulletin in all of these determinations. We are committed to very carefully following the rules and procedures for making a decision between notice and comment rulemaking and the issuing of guidance. And if there's ever any question, that is done in consultation with our solicitor and with OMB. We are confident in this situation when we were responding to the terrible tragedy of an explosion that took 15 lives and injured hundreds of more people, that when we looked and were responding to an executive order then issued by the president to say, close the gaps, right? We have to take action and make sure that a preventable explosion like this does not happen again. Close those gaps. When our folks looked at the regulation to look at the question of, is there a need for new notice and comment rulemaking? Being very clear that the regulation, both the preamble and the reg text were clear, but guidance was not. And so there was a need to update that guidance to clarify it. If there's specific questions that you have about the Ragaget memo, I want to be sure that I get you an accurate answer.
Sure, and we will definitely go pursue that, and we'll try to follow up on that. But the real issue is here, there seems to be a change in the reg on it, and I understand a response to what happened in the explosion. I'm not, the reg seemed to shift before we even determined all of the reasons for that. Was it the assumption then of the agency that the reason for that explosion is that they were not following the Reg-A-Gap standards, that they had done their own process? Is that why the shift occurred?
Yeah, we do not think that any of these memos represented any change in the regulation.
So right? then could the enforcement, I guess that's really the issue then. Ms. Sager talked about binding, whether it's legally binding or not. If an entity created their own process, could there be a court challenge to them creating their own regulatory process? Because previously that was allowed. Would that still be allowed now for them to be able to create their own process?
I'm going to be honest with you. Your question about them creating their own regulatory process, I'm feeling like is getting into something outside
That's okay.
of my area.
Just and we can come back and we'll talk about it more in the second round. But previously there were two options. You could follow this set of standards on it, or you could develop your own process as long as it meets this, because the end was what they were after. Does it provide this safe management process on it? Now, developing their own process seems to go away, and you just have to do it this way. And that's what we're trying to figure out, what just happened. If many companies that have created their own process, now that's suddenly not legal, there seems to be a legal shift that has occurred there. And we'll follow up on that in the days ahead, or not in the days ahead, but we'll follow up with letters on it, but talk about it in the second round as well. I'd like to recognize Ranking Member Ms. Heitkamp.
Thank you.